I think that will impact you. But first of all, I wanted to point out about a couple of things that they didn't do. Okay? One of which was to address the Obergefell decision that's now 2 years old. It came down in the midst of the 2015 legislative session. And this was the case that legalized gay marriage all the way across the country. And our legislature has not addressed the numerous statutes that this decision impacts. An example of which is the statute that addresses marriage licenses. You can see down here, it says a license may not be issued for the marriage of persons of the same sex. So we have statutory law. We still have a state constitutional amendment. Was passed way back in the Clinton era when they had the Defense of Marriage Act at the federal level. That all conflict with the Obergefell decision. I don't see states being able to roll that back at this point. Okay. The thousands of people now that are getting married under state law pursuant to that Obergefell, what would we do with those folks? So I don't think we at a point where the legislature, either through inaction or even direct action, is going to be able to roll that back. The other thing that was a little disconcerting for me as a family law practitioner was a bill that Matt Krause had, out of Fort Worth, had proposed in the past. My understanding now, it got a lot more traction. It actually got on the House calendar at some point. That's to do away with, that statute, if it passed, would do away with our insupportability ground for divorce. And that's the ground that says your marriage has become irreconcilable due to discord or conflict of personalities that has destroyed the legitimate ends of your marriage relationship and prevents any reasonable expectation of reconciliation. That's what we call our no-fault ground for divorce. I practiced in an era, back in 1981, early 80s, when we still allowed for causes of action for alienation of affection. We had the insupportability ground, but we did away with those causes of action, that kind of litigation, because we were trying to take family law kind of out of the muck, if you will. And if we do away with the insupportability ground, someone's going to have to plead and prove a fault ground for divorce again. So you had situations back then where people were actually committing perjury to get divorced, or they go out and intentionally sleep with another person other than their spouse in order to satisfy one of those grounds for divorce. I don't think it's going to go away. I'm hoping that it doesn't get more traction in 2019, but we'll see.
What's the rationale for that attempt?
This,
No. Why is that legislator trying to revoke that insupportability?
I have to assume it's a religious, faith-based argument about marriage. Okay. I can tell you, as a family law lawyer, there are times when people don't qualify for one of these fault grounds. But these people just can't get along, can't stand each other, and don't want to be married. So, we've seen other similar kinds of approaches with trying to slow down divorce, putting up further time distances before you can grant divorce, things like that. Other states have something called covenant marriages, where people contract on the front end to make divorce a little bit more difficult of an option on the back end. I'm not really opposed to those because people are, agreeing to those on the front end. I would just hate to see us go back to a time when we had to have fault grounds for people to get divorced. When you start thinking about how the human brain doesn't become fully developed till we're 25 years old of age, and how many people get married younger than that. I did. I got married at 19.
Wow.
The first time. So maybe that's all I need to say on that. All right, the other big thing that they did is to do away with underage marriage in Texas. You have to be 18 years of age now. The statute on parental consent, where you kid between 16 and 18 could get married with parental consent. And if you're used to doing a lot of family mediated settlement agreements where they're articulating and the individual rights and duties parents have, the right to consent to marriage is in there. You don't need to put that in anymore, okay? Because this statute's been repealed, so parents can't consent for their kid to get married at an age younger than 18. The other one they repealed was always an interesting one to me because it gave the minor the right to consent to marriage at any age. Theoretically, a 5-year-old could petition the court for an order directing a clerk to issue a marriage license. So now, in our state, if you want to get married, you got to be 18, or you have to file a petition to have your disabilities of minority removed. Okay? Some people refer that to an emancipation statute. In Texas, a minor 16 years of age or older who's living separate and apart from his parents is basically self-sustaining regardless of the source of income, can petition a court for removal of their disabilities of minority. Essentially what that does is giving a minor the capacity to enter into a contract. And that's the only way someone under the age of 18 is going to be able to get a marriage license in Texas. If they're from another state and they're going to have to provide a certified copy of one of those emancipation orders out of another state. Yes?
When did all these take effect?
September 1st.
Thank you.
Most statutes that are passed in the legislative session will have September 1st enactment dates. Sometimes the bill will specifically state that it becomes effective when the governor signs it. And there are times when the governor will sign a bill, you know, like July, it might go into effect. Most of the time it's September 1st. So that's a big change. So if you're going to be drafting mediated settlement agreements, parents typically never fought over the right to consent to marriage. Did anyone have a case where they were arguing about that?
So are you saying they left the one for military and it's just, because those two are combined on the same line?
No. If they have to have a order removing their disabilities of minority.
No, meaning we no longer have to include whether the parents have a choice to allow their child to marry, but that same line said
Yes,
could
yes,
they be
yes.
armed forces, so.
Yeah, they still have to consent to enlistment in the armed forces.
Under 18.
Come again?
Under 18.
Right. It's pretty unusual for the military to take anyone now. They want to see people with finish high school at least. They want 18. You know, if we have a major conflict somewhere where we need bodies, maybe we'll get around to that again.
But it's high school and not 18, right?
What's that?
Meaning, you got these kids that are excellers and graduate high school at 16. It's high school, I guess, is that right, or?
Or what are we talking
At
about?
18.
We're talking about
Mili- Well, it would have been on this too, but not anymore, but military, let's just say.
You're gonna have the same issue. Just because you graduated high school doesn't mean you have adult capacity.
Okay.
You know, I started college at 17. I couldn't legally drink. That was a real handicap.
The high school one is about child support.
Come again?
High school kicks in about child support.
Well, you can be obligated to pay child support after a child turns 18 as long as they haven't graduated from high school.
Yeah.
Yeah, I've had a couple of cases where kids were actually getting college and high school credit, okay? And that really irked the parent who was paying college tuition. And then they still want, we're gonna have to pay child support. All right, this was, this is a new provision that went into the family code. And I'll talk to you in a minute about why this came about. But pursuant to this let me just back up a step. The family code says a court has to make decisions regarding children that are in the best interest of the children. And for a long time, it was believed that a court had the discretion to set aside a mediated settlement agreement if the court determined it wasn't in the best interest of the child. Okay? And in a minute, I'll talk to you about a case decision that came down a few years ago that addressed that. But this statute says a court may decline to enter a judgment on a mediated settlement agreement. A, if a party to the agreement was a victim of family violence, and that circumstance impaired their ability to make decisions. So what was that sound like? Coercion, influence. Okay. Or the agreement permits somebody to basically reside with or allow a child to have contact with a sex offender. If they reside in the same household, somebody has unsupervised access, the person who is a registered sex offender has unsupervised access, and the agreement's not in the child's best interest. So under these very specific facts, a court can set aside the mediated settlement agreement that you spent, a whole day mediating. Okay? And this came out of the Stephanie Lee case, 2013. In this case, mom and dad were divorced. Mom decided to marry a gentleman who was a registered sex offender. Dad found out about it. He filed a motion to modify it. They go to mediation. The mediated settlement agreement gives dad the right to designate, at that time the language in the statute was established the primary residence of the child. Okay? But it gave mom visitation. But then they tacked on this other requirement on mom, in that when the child was in her possession, she had to make sure dad was more than 5 miles away. Her new husband, rather, was more than 5 miles away from the child. And she had to let her ex-husband know, dad, what the make and model of this person's car was and where that person was going to be while she had possession of the key. So that's what they agreed in mediation. All right? And dad decided he didn't want to have a judgment entered based on that mediated settlement. He had buyer's remorse. He started wondering about that. So he basically refused to enter judgment. The court basically decided, no, I'm not going to enter the judgment because I don't think this is going to be good in the best interest of the child. Okay. But what the Texas Supreme Court said, making a call just on best interest by itself is not enough. So even though the family code says a judge has to make orders, render orders with respect to kids that are in their best interest, the Supreme Court saying the judge can't disturb an MSA that the parents have agreed to just because the judge doesn't believe it's in the best interest of the child. Okay. However, the court went on to say that protective action is required when the trial judge determines that such action is necessary to safeguard the child, and refusal to enter the judgment is available as a protective tool when the child is endangered. But in the Lee case, the court determined the kid wasn't in danger because of those provisions they tacked on at the end, where the guy was enjoined from being within 5 miles of the kid, and mom had to inform dad of where this guy was going to be and the make and model of his car. So that's kind of it really clarifies the options a judge would have. It's going to be pretty unusual for a judge to be able to set aside a mediated settlement agreement. So you as mediators can get as creative as you want. Okay? As long as there's not an issue of danger to the child or a need to protect the child, okay, mediated settlement agreements can be pretty creative.
And this was written with the basis of children. Did they address anything that has a basis of someone saying, hey, I don't want to move forward with this mediated settlement agreement, whatever?
It means that the court's probably going to have to enter the judgment based on the mediated settlement agreement.
Because these were the only things they addressed.
This is the only time the court cannot enter a judgment based on the mediated settlement agreement. So, as a lawyer, I've always known that to prove up an agreed divorce case, they have ex-retired judges sitting as visiting judges, or even the sitting judges. They do uncontested prove-ups in the morning. Go in there when they got like 10, 15 people waiting to prove up a case. Hang back, go in there when you're like 11th or 12th or 13th, and then prove up a case because the judge isn't going to read it. Okay, they just want to move everybody out and get on to their regular dockets. So whenever I've had a judgment that I had some uneasiness about, that's what I would do, and that's what I would do in the future.
This case was written about by Justice Deborah Lemon in
Right.
the Texas Bar Journal.
Right.
And she explained her analysis, how they came about this decision.
Yeah, she did a good job with that article.
Yeah.
I was guilty of telling students, until that Lee case came down, that, a court, it still had to pass the best interest test. So if people got too crazy with their agreements, there's no guarantee a court was gonna accept it. All right, this was passed in the 2015 session. They called it the Dentist Full Employment Act. It had most people weren't aware of this. The effective date for that provision was September 1st of 2018, and it's still 2018. So I've had people arguing in mediation that you gotta pay dental insurance, you gotta provide it. It's the same as medical insurance now. Okay, and as a mediator, if they got lawyers, I don't generally challenge the lawyers on the law, but I knew that, no, you got another whole year before anyone under the statute would be obligated to provide that.
Is that Texas?
Yeah, this is all only Texas.
Only Texas.
Yeah.
So I had a case where one was someone's Arkansas and one parent was in Texas. They were fighting over which rules,
They were gonna have to decide which state law was gonna apply to their
the lawyers
case.
helped the fighting part.
What's that?
The lawyers helped in the fighting part.
Well, lawyers are good at that sometimes. So, dental insurance usually is not that significant a cost to most folks, so oftentimes they're willing to provide it even though they're not obligated to do it.
I have a question.
Go ahead.
So let's say you have a mediation today, in which you get them to agree to it, would they be required in 1 year to start doing it? It wasn't in the Senate?
They could come back and modify their decree and get dental insurance ordered.
So they could, all right, so.
Again, the
they could-
statute doesn't go into effect until that date.
Right. but what if
So
it-
any orders
It's not
entered,
retro. It's
any
not-
orders entered after that date are gonna have to address dental insurance, just like medical.
Would it be
insurance.
wise just to have that already in there?
I mean, that as of September 1st,
Right.
2018.
To change it?
Well,
Well, it doesn't mean that every child after that who's in a divorced family has to have dental insurance because they were divorced prior to
They would have to
September.
someone would have to file a motion to modify and get an order compelling someone to provide that
So
insurance.
just leave it out, don't even worry about it.
Well, sometimes it's just a matter of being a good parent,
Yeah.
okay, and providing the insurance. Again, the cost usually is not
I'm
You have
significant.
to pay
saying don't put it
50/50
in.
expenses on it.
I can tell you as a lawyer, I've never been unable to shame my client into providing dental insurance when it was available to them.
And the thing is, your question, is it okay to put in an MSA regardless of what the item is?
Yes.
That
But
at
it-
at a future date, this would be, but it's not now.
You could do that.
And if you're aware of the law that's gonna kick in, the child's 7, and it's gonna obviously go beyond.
But it doesn't, just because the law's effective doesn't mean it's gonna affect you. You have to have a current case.
Oh, right, no,
Okay,
yeah.
all right, all right.
I think everybody
Kids
understands
involved,
that.
Yeah.
It's just been amazing to me how many times I've heard mediation, you gotta provide dental insurance. You gotta read the fine print sometimes. This is what Ron was talking about. All of you who do family law and have family mediation and have your certificates are gonna be required by January 1st of this year to have another 4 hours of this domestic violence dynamics training. Okay? There's an organization out there called the Family Center,
Texas Family Violence, wait a minute, I'll tell you.
Texas Center for Family Violence or on
Yeah,
Family Violence.
yeah, on family.
Allegedly, they were behind this change. So I learned about this law this summer. We got together as an organization, SWCRN, we thought, well, we're gonna offer that training. We have a faculty member here in the counseling program, Sarah Feuerbacher. She's the director of our family counseling center. And she's had a lot of experience in this area. She's worked in domestic violence organizations. So I got her to agree to do the training. But if you read it carefully enough, it says developed in consultation with a statewide family violence advocacy organization. So what are those?
Yeah, what is that?
Okay, well, the one we just mentioned is one of those, right? So I asked our speaker to put together a program, and we were going forward with that, and then I realized that just consulting with the family place folks, which we did, have them bless our curriculum, probably wasn't enough. So I reached out to this organization and talked with their training coordinator, the person responsible for all their training. She didn't know what I was talking about. And this was just a few weeks ago. Since then, I've gotten to their executive director, and they've gotten on board. I got enough emails going back and forth now where they kind of comment on our curriculum to feel comfortable in saying that we have a curriculum now that's been developed in consultation with a statewide organization.
Texas Council on Family Violence.
Okay.
And that is due, you're to obtain that training by January 1st, 2018?
This is the footnote
I
to
mean,
the
that is
statute.
very little time.
Yeah, and for anyone else getting trained that wants to do the basic 24-hour family mediation course, this has to be embedded in that curriculum, so they'll have that going forward, but everybody else, including myself, has to have this training. So we're offering that on October 28th. It'll be from 10 to 2:30 thereabouts.
And there will be a second date that we'll be doing in, I think, a month.
We're gonna
later.
film it.
Yeah.
The
That's
speaker's
the
given us permission to do that.
TMCA symposium. That day is the day that.
That is?
Yes.
The-
TMCA symposium, the one for the credentialed mediators, is that same day.
We'll have to talk about that. but,
They would need to change it.
I don't know how many people are gonna be interested in what they're rolling out.
I don't know if you're required to have it by January
Yeah.
1st, 2018.
We're running out of time.
You're running out of time, that's right.
And when I talked to this organization, they haven't offered this training yet. They're gonna now get their ducks in a row. They saw we were offering one, so I assume they're gonna roll something out at some point. Any questions about that?
This law, this particular provision, you can mediate families, you can mediate divorce cases, but if there's a child involved, this is training you have to have.
Right, cause it's just,
Who's policing?
you don't need this 24 hours to do a divorce case without kids.
Police yourself.
If you just do the 40-hour basic mediation course, you can mediate divorces where there are no children.
Yeah.
Well, I guess my point was, it's just like anything else. Who's policing any of that? Who's policing right now whether or not you've even done the 40 hours and 26 hours and?
You know, I at least wanted to have enough evidence
I mean,
to
I
show
think
that
we should.
compliance with this. And I think we have that now, so. Our speaker wasn't really happy about having to revamp all our materials, but she wants.
You said there's going to be another date offered too?
We're going to play
We're gonna
the
record
video
it.
of the program on a Thursday in November.
Yeah.
It's a 7th.
Okay, that would count
Yes,
as a 10.
It'll be the 4-hour.
4 hours. Yeah.
Course.
You'll get emails, don't worry.
No, because you're going to pay for this program.
Maybe if you pay, maybe you
Pay for
could watch it when you want.
Well, we gotta pay the speakers, and we got some costs with the lunch and
Right, so
the venue, but.
we're gonna have it that day.
It's $200 for non-SWCRN members and $125 for members. All right, everybody good about that one?
Yes.
All right, we already talked about that. Now on to mediation ethics. When we started the dispute resolution program 23 years ago, it was a certificate program. About 5 years in, it became a full master's degree program. And at that time, we had embedded in the core and curriculum and required courses an ethics class that I taught. And it was a struggle back then to come up with enough content to cover a 10-week course. Because there is not a lot of legal activity surrounding mediation ethics. Okay? There are a couple of law review articles out there that have looked at mediation liability for mediators. Okay? And quite frankly, most of the cases they cite, and there are few of them out there, are not from the United States. There have been some cases locally, but there's just not a lot of activity in this area, which is a good thing. And we'll talk about why that is in a minute. Okay. But what did generate a lot of interest in a flurry of postings on all the typical ADR and mediation sites was a federal district judge's order back in May, when he ordered actually it was JAMS had provided the mediator, ordered them to preserve the notes from the mediation. Okay. This was an employment case where a woman was going after the law firm she'd worked at, and one of the lawyers there for the firm allegedly made some threats to her. Okay? So now they didn't settle, so now she's wanted to add to her causes of action. And she wanted to be able to access, for purposes of her lawsuit, the notes the mediator might have recorded about what happened in the mediation. Okay? So the judge entered a restraining order ordering JAMS and the mediator not to get rid of their stuff. These are just some of the quotes that were out there on different sites. This is uncommon. The whole reason behind preserving confidentiality is so people will be open with each other. How many times have you heard that? Okay. Mediators can't be compelled to testify unless there's bad faith. In our state, bad faith is not enough. I've been subpoenaed twice as a mediator. And I don't have an accurate count, but I've done more now than 1,700 mediations, and it's less than 2,000. Okay, all those mediations I've been subpoenaed twice. Okay, and both times the judges quashed the subpoenas before I even had an opportunity to start preparing a motion to quash. In both times it was because the lawyer wanted to complain about the bad faith tactics or the bad faith mediation of the other lawyer. So in some states, this might be an option, but it's not in our state. Allowing mediation notes to be used in a lawsuit is quite disturbing, undermines the whole process. You agree with that?
Yeah.
Anyway, the judge subsequently vacated that order, but it wasn't really because the judge was addressing the issue of discoverability of mediation notes. JAMS came out and disclosed that they keep all their stuff for 60 days after the mediation anyway, and the mediator had agreed to preserve the notes. So basically what the judge says, we don't need the restraining order. They got enough time, that 60-day window, to do whatever discovery they're gonna need to try to get access to it. Now, I've been watching the case to find out if there's gonna be a ruling on discovery requests, okay, or a subpoena served on JAMS or the mediator to get access to that information. Because then the judge is gonna have to really specifically rule on whether or not the mediation notes are discoverable. So far, I haven't seen where that has happened yet. So I asked you two questions. Can a statement made at mediation ever be used in court? Let's start with that. In our state?
Yeah.
Yes. When?
Elder abuse,
Okay.
Child abuse.
Child abuse?
Something factual, meaning something that's on paper and factual. I mean, it's just a statement of evidence.
Disability.
What?
Disability.
A disabled person, abuse or neglect. Yeah, we have reporting statutes for our vulnerable citizens, right? Kids, elderly people. I'm gonna be 62, so I tell my wife she's got 3 more years to smack me around. That's gonna be elder abuse. I'm 65.
Already the elder abuse.
There's two basic bodies of rules, if you will, that are ethics rules for us here in Texas. One is the ADR Act, that's been around forever. And then we have the Texas Supreme Court Guidelines for Ethics. And what they have to say essentially is that what happens in mediation stays in mediation. So communication is confidential, not subject to disclosure, and may not be used as evidence against the participant in any judicial or administrative proceeding. That seems pretty straightforward, right? So they can't be used, right, outside of these reporting statutes. Another section talks about records. Okay. Oral communications. They did have this one, if it's admissible or discoverable in a means of outside the mediation. You know, I first started mediating back in the mid-'80s. I did a bunch of little insurance cases. And insurance companies were sending adjusters with no settlement authority. And they were just using the mediation as a discovery tool. What information could they use, or could they learn, which could help them define their discovery requests after the mediation to get the evidence that they couldn't get in because of what happened in the mediation. So that tactic is still out there. Courts have got wised up pretty quick. Now, the mediation orders require someone with settlement authority to be there or to be available to provide the settlement authority. Okay. But essentially you see this over and over again. What happens in mediation is confidential. And why is that? Why do we want it to be confidential?
That's what makes it work.
We want people to be able to freely exchange ideas and open up and discuss their cases, not worry about it impacting them in a lawsuit. Now, again, there are a lot of lawyers out there who don't allow their clients to disclose much during mediation. Okay. They're always worried the case doesn't settle now, it's going to be hard for me at trial, all that kind of stuff. This is another section about records. All matters including the conduct and demeanor of the parties, the case where the judge entered that restraining order, a lawyer for the firm blew up at the woman who was suing the firm and shouted some things that they probably wish they hadn't said. So, does that have to do with the conduct and demeanor?
Yeah.
When I was a young mediator, I had 2 Dallas County judges call me after cases didn't settle and start badgering me about what happened. And they wanted to know basically who was the bad actor in the mediation. And, you know, I was savvy enough to say, I can't tell you that. I can't even comment on the demeanor of the parties. I never got another referral from those judges after that. So I have to assume others might have been telling them what they wanted to hear. But how willing is someone going to be to open up and really talk about their issues in their cases if they know this kind of stuff goes on? Right? You know, I spent a lot of my time in the counseling world, and the confidentiality surrounding counseling sessions is, you know, a cornerstone to the success of those interventions, just like with mediation. Now we have the Texas Supreme Court approved ethical guidelines. As a lawyer, I love that term, guidelines. Their preamble says these shouldn't be a basis for discipline in and of themselves. So creates a lot of interesting wiggle room. Mediation should not reveal information made available in the mediation process. Information is privileged, confidential, unless the parties agree otherwise, or as may be required by law. Shouldn't permit recordings or transcripts. It's not a bad idea to embed in your mediation documents that you, as the mediator, do not agree to any surreptitious recording, either audio or video. Been involved in some situations where I'm pretty sure that happened. Texas is known as a one-party state. So as long as both people are in Texas and they're a party to this conversation, either one of them can secretly record that conversation. Okay? Unless you put the other party on notice that you don't agree to any recordings. So it's not a bad idea to embed that language into your documents. We had a woman who called up and wanted us to go after her ex-husband because she was pretty sure that he had left a recording device in one of our main mediation room here, where we were bringing people in and out. And when we talked to the mediator thought she remembered a time when his briefcase was left in the room. Okay, so he could have been recording. And the wife was convinced he had, because after the mediation, he was sharing, he made comments to her that indicated that he had to have either overheard in some way their.
Had it settled?
Yeah, it did.
Yeah.
So would you capture that in the agreement to mediate signed up front?
Yeah. Yep. You know, they could still do it, right? But at least then it's an illegal recording. That's an interesting question. What do you do as the mediator? This is a crime committed in your presence, or your space, on your watch. You were a victim.
You can sue one of the parties. I don't know.
Are you?
No.
You know,
I
do
find
the
that
rules
out.
prevent you? Is there anything in these rules that says you can breach confidentiality if somebody illegally records you?
You can withdraw,
What's that?
you can withdraw.
If you find out about it
Yeah.
in time.
They have to.
You know, the 2 times where I felt it happened here, cases were over and settled. The woman I was just mentioning, I told her, you know, if you think this is a problem, you gotta take it up with your lawyer and the judge. We can't do anything about it.
I had a case right downstairs where one of the parties was able to hear through the wall. And this guy suddenly pops into the room and says, I heard everything she said. And I'm saying, wait, you're not supposed to hear any of the stuff. And I had to move into a further room.
You know, I had a mediation on a Saturday. It was downstairs in the earlier days of the mediation center. We were all downstairs. And I had left the husband in the big conference room that's down there. Some of you may know it. There's a Keurig machine down in there. And I was in a smaller conference room in the next aisle over talking to the wife. And we were talking about some offer that she wanted to present. And there was something I needed that in a notebook that I'd left in the other room. So I got up to go in the other room. When I opened the door, the husband fell in. He had been leaning up against the door.
Not fun.
So what do you do with that?
What did you?
I shamed him good. You know, I took him back to the other room, came back, and I said, what do you want to do? I said, I can shut the mediation down, it's gonna be your call. You know, that was something you shouldn't have heard, you know. Her response to me was, my husband's a mediator, let's just keep going. But, you know, as a mediator, that could trigger your inability to remain neutral, right, or objective. And, you know, if you're that offended by it, then perhaps you would need to shut the mediation.
Right.
Yeah, people are interesting, aren't they? This is another provision under the guidelines. Shall not reveal information made available in the mediation process. Oh, we just saw that. Am I flicking this back as I'm walking around and talking? This talks about child abuse there. So what's the standard for reporting child abuse? We're talking about family law today. So what constitutes that? What's your standard, reporting standard?
You mean, what do you do when it?
What does chapter 261 of the Texas Family Code say about when you are obligated to report child abuse?
As soon as you find out about it.
Yeah.
Cool.
Once you believe it occurred.
It's cause to believe. That's a pretty high threshold. There are a lot of states out there with reasonable suspicion, cause to suspect. Ours says cause to believe. So what do you need to have to reach that threshold? I have never had to stop a mediation to make a child abuse report, but I've done this tactic many times. If it's a family law case, I never start a mediation without talking about the child abuse and reporting statute in some way at the beginning. And it always happens when I'm meeting one-on-one with one of the parents. And they'll start going down that road where I'm getting the sense that they're gonna start telling me what a rotten SOB that other parent is. And I always stay alert for that, at least in the initial individual sessions, and I'll stop them. I said, remember when we did this opening and we talked about child abuse and neglect? If you share information with me that causes me to believe that your spouse has abused and neglected your child, I have to make a report immediately. And then I have to tell the reporting authority what I know and how I know it. And I'm gonna have to tell them that you brought this information to me and you didn't report it. That's a Class A misdemeanor, and you can go to jail for up to a year for not having made a report. Now, what is it you want to tell me about your other parent? I've never had another word after that that would even suggest abuse or neglect. Does that mean it didn't happen? I don't know. Okay, but I also know that allegations like that get loosely tossed around in custody cases. Okay? But if someone rolls that information out there and you believe a kid was abused or neglected, you're supposed to report that immediately. All right, so I asked the question a few minutes ago, can you use a statement in court mediation? Based on our rules, unless it falls in one of those reporting statutes, I'm not sure I see an option. What about should? So I asked cases of fraud. There have been times in this country where a mediator has been compelled to testify as a fact witness when there were allegations of fraud perpetrated in the mediation. What about a crime? We talked about the illegal recording. That's a crime. If you find out about it during the mediation, would you report that? Would you shut the mediation down? Maybe. Can you trust this person not to record you? I mean, you strip them down to their underwear to bring them back in the room?
That would be interesting. What kinds of cases of fraud? What would a mediator have knowledge, firsthand knowledge of?
I've been in mediations where people didn't have all the facts. Okay? I would say this, if they're using you as a conduit to transmit inaccurate information, you have an obligation. I would step out of the mediation. I would just shut it down and just say, I can't go forward. And I don't think I would disclose why. Okay. But the cases involved, one was altered documents, financial statements that people knowingly provided somebody and it had to do over the sale of the business. They knew were inaccurate, things like that.
IRS, I mean, I see it with falsifying information to the IRS.
You can't do family mediations for too long before you find out about all the people cheating the IRS out there. And that is a heinous, shouldn't that be a capital crime?
Also, property that one spouse has that they don't want the other spouse to know about.
Yeah. And sometimes people just are so gleeful about getting one over on their spouse that they want to tell the mediator.
No.
So what do? You shut the mediation?
You know, you have to determine your ability to remain neutral and objective after that. I will tell you this, I learned a long time ago that people make bad deals and you don't know why. And sometimes they have good reasons for doing that. And just because you think it's a ridiculous, lopsided agreement, it doesn't mean that they don't know what they're doing. I did a case, one of these credit card cases years ago where a woman was being sued for like 15 grand. And clearly the statute of limitations had ran. The person bringing the lawsuit was the third owner of the account. They didn't have all the underlying documents. So this woman, had she hired a lawyer, could have easily beat that case. And she agreed to a $12,000 settlement where she was going to put $6,000 up front and pay the rest off. And so after we did the deal, I'm going in there to give her a copy of the MSA and shaking her hand. She goes, "You probably think I'm an idiot, don't you?" I said, "No, ma'am, but at least I'm curious. Why did you agree to this?" He says, "I knew I could have beat this. But when I borrowed the money, I intended to pay it, and things happened. My husband died, and I just couldn't pay it back. Now I'm in a position where I can, and I owe the money. I want to pay it." You know, that makes some sense, but the person getting the money is not the person she originally borrowed it from. They sold the account for pennies on the dollar. But this was a person that had a lot of integrity. You know, you don't run into many people like that. But that caused me to really sit back and realize that, hey, you don't know why people do what they do. And it's not for me to be the arbiter of fairness of their agreements. Yes, sir.
If you choose to shut down the mediation for whatever reason, conduit for fraudulent information, you said you wouldn't tell them why?
You can't violate these confidentiality rules in giving the explanation why you're shutting it down.
Okay, so that you got one party that possibly knows and the other party doesn't. You just shut it down. They paid their money. You get to keep the money, well, I decide I don't wanna do it.
You know, I haven't ever had to do that, but I would probably refund the money if I'm the one shutting it down. I would do that. I wouldn't have to, but I would probably would do that. And I would just say something has come up and I'm not able to proceed as the mediator in this matter. And I would give them their money back and send them on their way. It doesn't mean people aren't gonna be upset with you. You know. The more you do this, the less you worry about people getting upset with you.
Had a situation where one party was clearly checked out, the other party was trying to hang on to the marriage. And went hours and just wasn't gonna settle, didn't settle. But after the other party was gone, the one that was wanting to hang on, and I had a suspect of what was happening here, but I pulled out this file, and it's that thick, and he said, you know, well, the reason I didn't settle, I know you think I'm crazy, but I have a case of fraud against this person. And it was a marriage to get citizenship. It kind of seemed that way. And, but I just figured he just made a bad decision, right? But then he said, you know, this family goes back, then he started flipping through all these financial documents. I can only approve fraud. I said, okay.
So he was saving his fight for another case?
Yeah, yeah, but when we had already like adjourned, and I just said, okay, well, sorry, you have to do whatever you think you have to do with. That, I mean, if I had found that out during the mediation, I could, if I felt uncomfortable with that, or just.
Again, if you, it's gonna impair your ability to remain objective or unbiased.
That's what I thought, okay.
And so if it was a court-ordered mediation and you shut it down, do you give them credit for having mediated?
I would basically report to the court that the parties appeared, a conflict arose for me as the mediator, and I shut down the mediation. Should you keep notes and records of your mediations?
No.
Any reason to do that?
No.
I keep all my notes until I know the judgment in the case has been entered and the case is finalized. Because I usually have language in there if they have a problem. In family, you get a mediated settlement agreement, and then they gotta do their divorce decree.
Exactly.
Right.
And oftentimes, there's lots of conflict over the
What-
conversion of the agreement into the
Right.
judgment. So I usually have language in there that I will help the parties try to resolve that. So I'll watch online to make sure the case has been closed and finalized, then I'll just shred it whatever I have.
But do
The
you
other
have
thing
to?
I do is e-file the agreement. So that's the other reason I wanna wait. I make sure, I wouldn't destroy an agreement until I knew it was accepted and filed with the clerk's office. But I've already said these cases against mediators are so rare, but there is a general 2-year statute of limitations for suits on negligence. So people have up to 2 years to sue you for being a negligent mediator. And if you've destroyed all your documents, that might be a problem for you in trying to defend yourself. It's not enough of a risk for me to keep the documents. The risk of being sued is infinitesimally small. And now that lawyers that I did a lot of mediations for realize they can come to SNU and get me for free, it's less of a problem because there's an immunity statute that covers me as a volunteer. I'll show you that in a minute. Yeah.
Do you keep the names and dates at all?
Um,
Nothing? Case number or anything?
You know, I did for a long time. Okay, I stopped doing it 3 or 4 years ago. I said, why am I doing it?
Don't you want your own statistics?
Not really.
I can't imagine.
It's amazing how
Imagine looking
things
at
that you
us
thought was
the
important
next day
before you
and
turned
going,
60 seem less so afterwards. Is there another hand? These are some of the reasons why, suits against mediators don't happen and why they're so difficult. There's a lack of uniformity in standards. In our state, the big ethics code is guidelines anyway, so, people could try to assert those as a standard of care, and a negligent suit makes it difficult. Mediators can't agree on a lot of things, like just how to define mediation. The ADR Act refers to it as a forum. The Texas Supreme Court guidelines refers to it as a process, okay? And you have the different styles. people are free to come and go as they please. They don't have to settle, right? They have this confidentiality shield, which is pretty strong in our state. So these are reasons why it makes it difficult. Damages are often difficult to prove. If they've settled, you know, what's the alternative to settlement? You go to trial, and they didn't go to trial. So how do they know they would have gotten a better deal or a better outcome if they'd gone to trial? So, and I mentioned that immunity statute. These are different kinds of claims. And when I did the law review article research, they said mediators could potentially be sued for. A couple of the lawsuits that made it, one was out of Australia, involved lawyers giving bad tax advice to convince people to do agreements. So essentially, they're getting sued for you know, giving bad legal advice or tax advice. But these are just some different causes of action that people might want to assert. I'm going to give you an example of what happened in the mediation. This may apply to that. The mediator wasn't the one doing the coercion. All right, this is the immunity statute. This is why you don't get paid when you volunteer at our mediation center. When we started the mediation clinic in cooperation with the Collin County judges, I had envisioned a kind of a sliding fee scale where people would pay, and the judges were on board with that, and we would pay something to the mediators, and then the legal affairs office for SMU came in and put the kibosh on that. They thought students running amok in a mediation center would subject the university to all kinds of liability, and they wanted to keep us squarely within the immunity statute. So the most we give you is a party, by the way, which is coming up in a couple of weeks. Let's talk about settlement agreements. What's an oral contract worth? Paper it's written on, right? So the ADR Act, if they reach a settlement agreement that reduces to writing, it's enforceable as a contract. Right? Court can incorporate the terms into their final judgments. Okay. The guidelines for mediators suggest that we should encourage parties to reduce all settlement agreements to writing. So here's the rub. You've heard this before. You've been to any TAM conferences. There are a lot of people out there, usually lawyers, who think it's the unauthorized practice of law for non-attorney mediators to draft mediated settlement agreements. Okay? One option is to do what's called a memorandum of understanding, which is not binding. Okay? You can offer that to parties on the front end. Okay? A lot of people don't like the fact that you're telling me now I got to go take it to a lawyer when the reason I came here in the first place is because I didn't want to have to use a lawyer. Right? I've created templates that we use here in our mediation center that people can use as a starting point or a basis for agreement, and those are lawyer drafted. Right? May not be a very good lawyer, but at least I could say they were lawyer drafted. Right? Scrivener's disclaimer. I'm going to show you Denise Cajola's very thoroughly worded disclaimer agreement here in a minute. But I have only known of a couple of people that have been approached, or at least, I guess I'd have to use the word prosecuted by the state bar for this unauthorized practice of law. One, I think, was Suzanne Adams. I think she died before the state bar was through with her. And now TAM gives out an award every year with her name on it, which is interesting. And then there was another gentleman, I won't name him, he was over in Tarrant County. But when you dig into their cases, what was alleged that they were helping people with their divorce documents after the mediated settlement agreements were entered into. The guy in Fort Worth ended up with a cease and desist order, then went to law school. Anyway, now he's being prosecuted and for all kinds of other shenanigans. But what he did was hire a paralegal to draft all the divorce petitions and decrees and stuff until a couple went in front of Judge Lehrman over in Fort Worth when she was a district judge with one of these legal assistant drafted decrees, and the judge said, "Who did this for you?" oh, it was Mr. So-and-so over. So she went online, found I wasn't a lawyer, and that kind of put a kibosh on his scheme there. But I haven't seen, and there could be other cases I'm just not aware of. So I don't know that it's as big a deal as sometimes people make it to be. I don't know. But you're gonna have to decide, and you probably already have, you've done some mediation, how are you gonna handle that? I do a lot of mediations now, even some I do for profit, where the lawyers send their parties to me. And oftentimes, I'm stunned about how little legal advice they've actually got, okay? And the lawyers want me to draft the mediated settlement agreement. They're just pushing these people off on me. They've sucked out whatever money they were gonna get, and now they want me to make it go away. So you have to just think through how you're gonna handle this issue. But you probably can't read all this, and I'll have to ask you. I was gonna make these slides available, but this is her language, but it's pretty thorough, okay? Where she's having the parties release her from any liability or responsibility for the agreement. And I'm assuming that you're spending a lot of time in preparing the drafts of these agreements. Am I right in that?
In writing them, yes.
Yeah,
Mhm.
yeah.
Always.
And then here, this is this what I call the Scrivener's disclaimer. That word's been around for 20-some years. The parties also declared that the mediator acted merely as a scrivener, relying on the dictation of the agreement by the parties and or their attorneys. So you can embed some helpful language like that. Right? Even if they're there with lawyers, I'd still leave that in there. You're making it clear that they have the right to consult with legal advisors. I guess you throw this in there, it's intended to be irrevocable because you're doing family cases. And they aren't gonna drag you into their legal messes. So that's about as thorough of one of these Scrivener's clauses I've ever seen. And I'm quite frankly stolen it. I didn't see any copyright symbols on it. I commend Denise on that approach. All right.
The only other thing that I have on that though is that, and we learned this last year when we had a speaker, is that the language that's in the front of those mediated settlement agreements, it was one of the judges in Dallas County, they all need to be in bold and underlined. There was.
You're talking about the section of the family code that says that a mediated settlement agreement is binding and it's not subject to revocation. If it spells out in the body of the mediated settlement agreement that it is binding and irrevocable, and those words have to be in highlighted text. So it stands out and differentiates from the rest of the language in there. So most people either capitalize and bold it, some people capitalize, bold it, and underline it. There are actually some appellate decisions where that language didn't have that different font and type to sort of stand out. And courts ruled that they weren't enforceable. So I got a series of real life scenarios. I've been collecting them for almost 30 years now. I'm up to almost 30, so it doesn't happen a lot. When I do this ethics talks to students, they get all panicky. You know, if I've done 1,900 mediations now in all these years, I've got 30 things to talk. So not a lot. So a party has disclosed information to you, but has refused to allow you to share it with the other party, and you know that with this information, the other party would not agree to the settlement he or she is about to agree to. They know something the other side doesn't know, and they're so gleeful about it, they just had to tell you. You know the other side
Well,
will.
let's turn it around, you know, it could be
Well,
where.
you can do that after we answer this.
Yeah.
So what would you do? You're the mediator.
You don't tell.
Can't tell.
Very cool. You can tell you again.
Okay, we pretty much established you can't talk. Based on all those confidentiality rules, you can't disclose.
Unless they give you permission.
Yeah. So,
Well, what I was gonna say was, it could be in a divorce case where someone's saying, look, I'm gonna be getting married here in a month, don't let her know. you know, something along those lines, it's the same thing, right? You
Sure.
can't say anything.
Yeah, but is
But
that,
that doesn't affect the
is that
litigation.
gonna affect the settlement?
Well, it could have. Let's just say if the other party.
If you're
visitation
negotiating pairing
schedule,
plans and
yeah,
things
I
like
mean, there's
that.
all kinds
Yeah,
of
I could
things
see
that
that.
could come into play.
I had the opposite happen where, they would have settled had they known that the spouse had compromised the pictures they were gonna show in court.
Pictures are always fun.
Yeah.
All right, we've already talked about these confidentiality rules. During an individual session with the wife, she tells you that her husband is really a drug dealer. The bar he owns is just a money laundering device. That she is afraid of him and that all she wants out of the divorce is $100 grand in cash and her car. She said her husband can keep the bar, their bank accounts, their home, its contents, their lake house, its contents, their boats, these other vehicles they have. She valued all of those at over 1.5 million. That was a conservative estimate. She says he's got plenty of cash. He's got these storage units all around the city that they're in other people's names. And that's where he stashes his cash, his guns, and his drugs. And he had been to the penitentiary once before, and he wasn't going back. So you're the mediator. What do you do?
I don't think you're not responsible for criminal behavior.
There's nothing.
You don't have to report criminal behavior.
Gary, what would you do?
I would say a word.
You wanna take it on a contingent fee?
I'd say the offer is.
Present the offer.
Right, I present the offer,
Present
that's
the
right.
offer.
So, I had one instance where,
No, you gotta answer, what are you gonna
I
do with this?
did, I said I would present the offer.
That's what I did.
Okay.
It was a pretty simple mediation. The guy chewed on the 100 grand for a while and finally said, okay, and I said, you really had to think about it?
He knows you know somebody who said that.
Yeah.
Yeah, well, he doesn't know what she told me the other way.
No.
So I was concerned a little bit about that, if he was wondering what I knew.
Did they have attorneys?
Right?
Yeah. Did they have attorneys?
No. Dad, the husband had hired a lawyer, okay, to file the petition. And I assumed he would probably draft her decree. Really, I think we were done in less than 2 hours. It took me longer to write up the agreement for them than
Usually does.
negotiate it. Halfway through a mediation, the attorney for the husband belligerently questions your competence. This old guy, this lawyer, called me an MF and said I was the worst mediator he'd ever seen. And this was pitching a fit. So what are you doing at it? Maybe it's never happened. Good. Hopefully it doesn't.
I just get back in their face and, I do, I just put them back in their place and get in their face and say, I'm in charge of the mediation.
I don't assert my dominance in that way, okay? But I'm not a dominant, forceful personality like Denise, but,
I would just
Usually
say
they
that
settle
if you
down.
think I'm incompetent, then.
I have a good poker face, at least that's what I've been told, so I can be churning with all kinds of emotion, it's really not evident, but, with this guy, I took a step back, because he was spraying me with his
Yes.
and I said, I may be an MF, and I may be all these other things, but I'm the only mediator you got today, and if you wanna keep working, I'm ready to hang in there with you. He says, we're not gonna keep working, he grabbed his briefcase, got his client, who was, I could see didn't wanna leave.
Right.
They go out in the hallway, and I heard them arguing, all of a sudden the client sticks his head back in and goes, we're gonna stay. And, we finished the mediation, but the issue really is more about me than them. Okay, would I be able to remain neutral and objective?
That's why I was saying, I would say, if you think I'm incompetent, then, yeah, let's stop the mediation.
I gave him a choice.
You know.
It's no skin off my nose. I don't care if people want it.
Right, exactly.
When I was young and dumb, I worried about it and I stewed about it, but now I do my best. I try to give them a good process, and if they act the fool and they do stupid things,
So
I
on
don't
that-
get upset.
Yeah, that's on them.
Just see it as drama. Some of these lawyers are just showboating, so.
That's true. This guy, I won't get into too much detail about it, but he had to stop practicing. He had some cognitive impairment. He was an older gentleman. I was appointed to media in one of his cases, maybe 2 months later, and I got the mediation order, I'm going, oh. He called me up on the phone right after I got it, because he must have got one at the same time. And he says, were you over at SMU a couple months ago? And I said, yeah, and he goes, I think I owe you an apology.
Wow.
See, that's great, you hung in there.
Is it reasonable to remind the attorneys that the mediation isn't theirs, but the clients? And that-
You know, I try to do that in a softer way. I try to tell the parties, this is your day, you make the decisions. Those of us who are at the table with you, we're working for you today, but you make the decisions.
You're the one that should be talking, not them.
You know, I've had some mediations where the lawyers refuse to let their client speak. You just gotta do the best you can. If you can get the lawyer away from the client, I did one case, I said, well, what's going on? And he goes, my client's an idiot, I don't want him saying anything. You're just gonna have to work with that. You know, I don't spend a lot of time trying to move lawyers off of some of their, you know, positions and their tactics. You just try to work with it the best you can. So the one with the lawyer blowing up comes down to whether or not you can remain impartial. During a mediation, you try unsuccessfully calm down two jacked up opposing lawyers who are screaming at each other. You move between them just when one of them tries to land a quick punch on the other attorney, and you're struck in the side of the head. This happened to me.
Really?
Did you hit him back?
It didn't hurt me. Okay.
So you say.
You can take a punch.
I've been hit a lot harder than that, trust me. So what do? That's you.
And take the money and run. You're fun
You put into the agreement to mediate, if I should construct.
Yeah.
You still have to pay me.
It's not the parties, it's the lawyers, all
You
right?
take advantage of their feeling bad about it to make the mediation.
Technically, is that a crime?
That's an
Yeah.
assault.
Yeah, assault.
Assault and battery. Assault's putting someone in apprehension of a battery.
Right.
just
okay?
weren't the victim
Assault and
until-
battery is when you actually
Follow
strike
me.
someone, that's a battery.
That's
Well,
a battery.
you had no
It's classic
apprehension.
definition of
Just battery.
assault and battery, right?
There was no assault. You had no apprehension, it just hit you.
So what are you gonna do?
Blackmail.
You know, I got them to back away.
It's about the clients.
I sent them back in separate rooms. I
Right,
talked to
it's
each of
about the
them
clients.
separately. I did talk to them away from their clients. And I said, look, I'm ready to keep working, okay? And if you guys can't be civil and you can't keep cooler heads, maybe we need to shut this down and come back. They promised to behave. I think they probably still dislike each other to this day. And we didn't settle that day. They did get a settlement before it went to trial, but we didn't settle that day. Lawyer representing the wife in a divorce mediation announces late in the day that he will refuse to sign a mediated settlement agreement unless he has paid $18,600 for attorney fees owed to him by the wife. His failure to sign the agreement would preclude a final binding agreement being reached. In order for a mediated settlement agreement to be binding in family law, you gotta have that magic language, and the attorneys who are present have to sign off on it, as well as the parties. So this guy was basically jacking up the settlement to get his 18.6K
So you-
paid to him.
You wanted his client to pay him that?
He didn't care where it came from.
Oh, he just wanted it, okay.
Okay. His client was stunned. You know. The last offer on the table was all agreed to, except for the part where each side pays their own attorney fees. And he, maybe correctly, was worried about how his client, the wife, was gonna pay. And he wasn't gonna leave that day. There was a settlement without money.
You're not
Now, so what do you do
obligated-
with
You're
that?
not obligated to respond to that because he's not your client. I mean, he's
Well,
not.
you just
Yeah,
have
you
to
leave it
sign
to
off.
the parties.
Take the other side down, this is what he said, if they wanna, that's up to them.
I went into the other room, explained what had happened. I said, this is a deal killer, then we're done. if you wanna try to talk about it, negotiate some more, I'm willing to work and see what can be worked out. And we did work out a settlement. They were actually selling a house, and I got the husband and wife together, because they both wanted this deal done. And they got on the phone to figure out, and online to figure out how much room they had left on their respective credit cards. So they cobbled together about $10,000 worth of credit card payments. This lawyer had his legal assistant come over, and they processed those credit card payments that day. And the rest of his money was gonna come out when they sold the house. I really had to give him credit, you know, because as a lawyer, I've been stiffed. This guy was getting this money. But as a mediator, it, you know, again, I don't care if the case doesn't settle. I say that, but, you know, I really do work as hard as I can. My mantra in mediation is I will be the most patient person in the room today, and I'll hang in there till midnight if I think there's a chance cases are gonna settle. But there's a deal breaker out there, and somebody wants to walk.
So Tom, you're saying that if there is an attorney on record, that the mediated settlement agreement is not
If
binding?
they're present at the mediation,
Oh, if they're not present, it doesn't hold?
doesn't hold.
Okay, that's what I was thinking, thank you.
A lawyer representing the wife in a divorce mediation chastises and browbeats his female client into accepting a settlement agreement. The client has indicated she does not think is fair. He reduced her to tears, and she ultimately signs it. I was in the room when he did this. Very prominent lawyer, I mean, you know, upper echelon kind of guy. And quite rightly, the firm hardly ever sends them to mediation. Usually a lesser light shows up. And I will say this, from my perspective, the deal was pretty good for her at this point. And this was a woman who, you know, I don't think anything was ever gonna be enough. But he blew up, he let into her like I've never seen anyone let into a client. And she was sobbing.
Yeah, but she's still gonna wake up the next morning and say, I was coerced into signing it.
Maybe.
And that would be between the two of them?
But I'm the lawyer in there, watching it, the mediator in there,
Yeah.
watching this.
Are you asking, do you let her go ahead and sign that, or, I mean?
Yeah.
Sounds like coercion.
It could
Well-
come back to you, I suppose, because you knew what had gone on, and she
You were
could
watching
complain
that
later
duress,
that.
yeah.
Well, you weren't complicit in the, you know, browbeating, but I don't think you have an obligation to tell her that it's a fair deal or not.
Well,
She didn't put a fair
the
deal.
mediated settlement agreement itself had language in there.
Yeah.
She's doing this
But didn't she
voluntarily.
look, I mean,
That's right.
if she's really that upset, right?
She could walk if
Maybe
she
she
wanted to.
could never really recover that afternoon. It takes like 20 minutes or so to calm down, even if you can calm down, you know. I would say if they wanna walk and pick it up again, I would let them do it.
I did get the lawyer to step out of the room for a little bit, told him to calm down, went back in there. She was still crying when she signed it.
Wow.
Well, that could be for lots of reasons.
Yeah.
At that
Yeah.
point.
But it was a good agreement for her.
Again,
But what is the rest of
I
it?
thought it was a
Yeah.
Yeah, from your.
pretty decent deal for her. I didn't think she was getting screwed.
But what if she was getting screwed? Would you have done anything different?
What's the definition of screwed?
You know,
In his opinion, he said she wasn't,
No,
so
no,
we must have
that's a
what
good
she was.
question.
again, my opinion, but
That's
my
right.
opinion is not worth it.
But you know,
That's
there are
right.
some people who just will not move off of something, you know? And, but unfortunately, if you have to witness that, okay, that's a hard thing for you to see.
But as a mediator, I could have shut it down at that point.
Yes, you could.
Yeah.
I could have.
You could have said to him, we need to step out.
Well, I did. I got him to step out.
Tomorrow's another day for this. That's what I would
It
have
would
said.
be a totally different situation if it was the husband.
Browbeating her. I would have
Oh,
separated.
yeah.
I wouldn't have let it get out of control.
Yeah,
like
we
that.
just
Mhm.
But
separated them.
her lawyer,
Yeah, if the lawyer, I would think from the lawyer's perspective, if she had plenty of money and she didn't want to settle, it's a money drain for her, right? You just let the litigation proceed and make more money. Why would he be so much interested?
Probably
in-
tired of her. She was.
Again, this was probably 6 o'clock at night. He was frustrated with her. I could tell from the very beginning he wasn't really happy about being there.
Yeah.
that day.
He was-
He's the kind of guy that likes to show up and try the case.
Yeah.
with the
So-
script that his legal assistant has written for him.
Where do you go from, chastising and browbeating, is that, were you talking to somebody, you talk to
Well,
them
that's how I
loud? At
described
some
what
point,
happened.
I mean, what is it, is it coercion, or are you just like, come on, what are you doing, just because somebody starts crying?
He was screaming at her. Screaming
Profanity?
at her.
Doesn't matter.
Is that the right line or what? I mean,
Should make
It's how it made her
I don't
feel.
remember him
Did
using profanity.
Did he make her feel like a tiny little ant, is what you're saying?
He basically called her an idiot.
Okay, that's what I was thinking.
Okay, he basically said that she was gonna get another lawyer, he wasn't gonna help her if this didn't settle, she'd have to start over with another lawyer, but he said it in a dramatic fashion.
He may have just been exasperated.
Well, I know he was
I think it
exasperated.
was. History, the history, we don't
I mean, is there a bright line, I mean, where?
Yeah, she got a good deal.
But I mean, if you should,
Again,
you're not allowed to yell.
the line is where you draw it.
Okay.
There's no hard and fast
But
rule.
there are people that can't make decisions about things.
It would, I don't know that there could be a case where, I would be impartial, okay? Because at the end of the day, I don't give a rat's behind about their deals, okay?
Right.
So, I haven't got to the point now where I felt I needed to step out of a mediation.
But haven't you ever had a client who, like, let's say, needed to write something and then was afraid to do it or didn't want to do it?
I see that all the
And
time.
you've had to talk sternly to them about, look, if you want to proceed with your case, this is the only way to proceed with your case, and I
You know,
can't
but
represent
if they have
you.
lawyers here, I don't do a lot of it. If they're without lawyers, I'll, again, try to do some reality
Okay.
checking with them, and I said, look, this goes to court, you're really sure that, you're gonna do better, what's that gonna cost you?
Mhm.
I tell my students is I had done maybe 20 mediations when I had this heady experience, and I realized I could lead these horses to drink the water I want them to drink. And man, I felt like a god for about 5 minutes. Okay? You do enough mediations, you're gonna get that sense, or you're gonna experience
Right.
it.
That's right.
Okay, but I also learned through trial and error that I can't lead those horses to drink that water too quickly.
It's true.
Could become a capacity issue. I mean, 'cause-
For her, yeah.
Because all of a sudden, they lack the capacity to be in the mediation, participate in mediation.
That's a possibility. I've been in mediations where a woman got on the ground, started flopping around like a fish. My client, I knew she was faking, the mediator didn't. The mediator panicked, wanted to call 911.
This is your client.
No, I represented the husband, this was the wife.
Oh.
She was on her third lawyer, she had scheduled 2 surgeries the week before trials and ended up in the hospital. Took us 4 years to get divorced, no kids. She did all kinds of interesting. The pro se parties to the divorce want the mediator to prepare a mediated settlement agreement in which the husband will be obligated to pay $1,000 a month child support. When under the guidelines with his little income, he would only have to pay $500. So they're raising the amount. Okay? This was so the wife could qualify for a loan to refinance the mortgage on the house she wanted to keep. And the plan was for her to kick back to him $500 every month. So what does that sound like?
Fraud.
Sounds like mortgage fraud. So what do you do with that?
I've been.
I guess that's.
In this
Make
instance,
the offer.
probably nothing, but it's still mortgage fraud. I don't know.
I didn't
What did you do?
finish the mediation because I felt I would be participating in their fraud.
Oh, you did, so you recused
So I said, I'm gonna shut down the mediation. I got out the statute, showed them where they could do a negotiated settlement agreement that would have the same binding effect. And they could draw off their own agreement, but I wasn't gonna help them with the mediated settlement agreement.
Well, they want that language in mediation settlement?
No, but that's what they wanted to do.
Yeah.
That's
tell
like
them-
knowing,
They
yeah.
can tell you what they were gonna do.
That's like knowing their
They
break.
just should have told you what they were gonna do.
Yeah, I mean, they could have really gotten along.
Did you tell them it was fraud?
But they could have done a lot of different things.
Yeah.
So what they did in a joint session was, this is what we're gonna do.
Did you tell them it was fraud?
I told them that there was a risk that this would be a fraudulent transaction.
No lawyers?
Is that financial disclosure?
There were no lawyers involved?
No, they didn't have
Pro
lawyers.
se.
Yeah. that's
So
right.
I did show them a way in which they could solidify their agreement without me. During a divorce mediation, learned that the husband is having an affair with a woman who is a neighbor and whose husband is a close friend.
Oh, God.
I was in a mediation, and the wife and her lawyer were showing me emails they had captured from the husband's computer.
Oh, gosh.
And I immediately recognized the distinctive email address for his paramour. And that was a woman in the neighborhood where I was looking at the time. My wife and I still see them occasionally, seeing her husband. So it's the only time that I really struggled with remaining partial. And I actually did 2 laps around this complex, trying to figure out what I was gonna do. And if you know my wife, don't ever bring this story up, because I've never mentioned anything to her about it, and we still see these people. We're still married, she and her husband. My husband and I are still pretty good friends. And it's still, well, we don't see him as often, because I really struggled knowing what I know happened, because these emails were really graphic. What?
Isn't that a conflict of interest? 'Cause you have
I had to decide,
stake,
could I remain impartial?
You cannot, yeah.
I did.
You did?
Again, it didn't take a lot for me. I came back, figured, well, we'll just treat this like any other case. Okay, and they got a deal done. I still did my job as a mediator, wrote up the agreement, and sent them on their merry way. About 3 weeks later, I was walking my Jack Russell Terrier. I had to get up at 5:30 every morning. It's still dark. And I knew this husband was in California on a business trip. And this couple had a house that fronted a golf course. So they had one of the few houses that had a front entry garage. So I'm across the street in the dark, and all of a sudden the garage door goes up, and I see something come in and jump in the back of the Suburban and like lay down in the seat. And then saw her come out, look around, get in the front seat and pull out. And I was pretty sure it was that husband that spent the night. So I don't know if it's still going on, hopefully not. That's the most challenging case I've had personally.
I see, when you're in a mediation, they wanna show you pictures, but I don't need to see pictures. I'm not a judge, I don't care. He knows you have the pictures, she knows you have the pictures, that's all I care about. I don't need to see the pictures. They wanna share too much.
I got, that was 8, I got 22 more stories.
Well, we can have 22 more sessions.
So I just want to give you a chance to ask any questions you might have, or anyone has their own story to share, kick around. Some of the other stories I know people in this room experienced.
I have a question. What if you know the lawyer's wrong about the law? They're telling their client the wrong thing.
I see that a lot. The last economic downturn that we experienced, there were a lot of lawyers pushed out of big firms, and tort reform, a lot of personal injury lawyers lost a lot of opportunities that they had in the past. They started doing family law. So I started seeing a lot of lawyers coming in representing clients in family law who didn't know what they were talking about. Right? I've seen it in areas of spousal maintenance and contractual alimony. Just lawyers being flat out wrong about the law and advising their clients. I don't say anything. That's between they and, I learned a long time ago, you don't get in between the lawyer and the client.
What if they ask?
Different story. If people ask my opinion, I'll give it. But I generally won't offer it unsolicited. It happens to me a lot. They get stuck. I deal with lawyers I've known for a long time. What do you think, Tom? I like this. Each lawyer is just adamant about what the judge is going to do.
Right. They all know the judge perfectly.
Yeah, get around and ask me what I think. And I've had civil cases where they get stuck and they say, well, we want you to make a mediator's proposal. And if I'm asked, I'll give them my opinion, but I won't do it till I'm asked. It's just another measuring stick on, people weighing what settlement offers. That doesn't happen that often. It comes up once in a while. I see a lot of people now, again, without lawyers, and quite frankly, that rule about not giving legal advice, I violate that all the time. I'm dealing with people who don't sometimes even have a clue about how they go about getting divorced. They come to mediation thinking that they're going to be divorced at the end of the mediation.
Yeah.
Okay, it's stunning how, uninformed some people are. I don't want to say ignorant, because they're not. They're just uninformed. Okay, so, and I, as a lawyer, I know that's a risk. I could be sued for giving inaccurate legal advice. But we're not gonna go forward that day anyway. And to tell them to go off and get legal advice, they're probably not gonna do it. Oftentimes, they can't afford to go do it. You know, that's how they end up here at SMU, right? They just don't have a lot of funds to work with.
Those examples you just made, was it here at SMU?
Some of them private practice, a lot of them were here. Yeah, I picked these out because they were personal to me. I have other stories that I've had to step into mediations or students have called me. I pulled these out because I was the mediator.
The challenge I find is not being an attorney and I kind of pro se. I'm not going to start to try to suggest anything. I think I've heard an attorney say something that's just not happening. And they don't know, and I have to,
You know, the family code is, we've dumbed it down, I guess. A lot of the legalese is out. So if you know the code, you can open it up
Yeah,
and
oh yeah, you can put, no, yeah,
let
but they
them
still.
look at it.
Sometimes, yeah.
And TexasLawHelp.org spells it out very simply. for
Right.
them.
It's dicier on some civil cases when they, you know, they're trying to prosecute their own claims. But, I love mediation. Yeah, I love, people are endlessly fascinating. You know, I started out as a kid in 4th grade reading every biography in the school library.
Wow.
So I was always interested in people. I wish people were as interested in me as I am in them. It's a people business. You know, like interacting with them. Any other questions? I can tell you about the dead baby case. You want to hear one more story?
Sure. Needs 4 more minutes.
I gotta fill up 4 more minutes. I was a lawyer in this case. A very wealthy man in Highland Park asked me to replace a lawyer that was representing his daughter. And the daughter was a heroin addict, beautiful girl, but took a sweater off. You could see the blue lines. She was already suffering from hepatitis. Married to a guy who was a mid-level employee for a defense contractor. They had a house in the Metroplex. And mediation hadn't come up, so I substituted in. I asked the other lawyer, you want to go to mediation? Fine, we pick a mediator. And I tell this young lady, because she moved out of the house that the husband was living in, and to write down what she wanted out of the house, pots and pans and whatever. She moved back to the dad's mansion, and dad was controlling about $30 million in trust funds, but those were all separate. So what they had was a house with a little bit of equity. They would be married about 4 years. There was a little bit of money in the guy's pension, so there wasn't a lot of community property. My charge was just to get this lady divorced as quickly as I could. So I'm in a small conference room with this young lady and her dad, and I asked her, did you write down what you want out of the house? So she reaches in this cloth bag and pulls out this crumbled up piece of paper and starts smoothing it out and slid it over, and the first thing on there is dead baby corpse. And then human hand, and there's all this other weird stuff. And at the very bottom is you start getting into China and other run-of-the-mill stuff. And I stopped looking at it for a minute. I said, are these things that you want to negotiate for? She says, yeah, we've been fighting over these from the beginning. And I said, do you want to talk to me alone? And she said, I don't care if my dad's here. He knows, I don't have any secrets from him. But here's their story. They had a satanic cult. One of the members owned a funeral home. Instead of cremating the baby corpse, because there were 2, she just wanted 1. She was being fair about it. Okay.
Oh my.
They would use that in ceremonies, and so I told her, I said, I'm not gonna be negotiating for any of this stuff above this line, and I folded the paper and ripped it off. I said, I'm not going there. The dad was crying. He was really bad shape. So I decided to go get the other lawyer out of her room, talk to her privately, and brought her out, and I showed her the top half of the list. I said, my client says they're fighting on this while they're not divorced. And she goes, that's nonsense. Your client's a junkie. And goes back in there, comes back out. Her face, I'll never forget it. Her eyes were huge, ashen. said, what are we gonna do? And I said, I don't know what you're gonna do, but I'm not negotiating for that, and I'm not telling the mediator. I often wonder, what if you were the mediator and they came in with that,
List.
yeah, list to divide up? I would not mediate that.
No, sorry.
Yeah,
It
me
goes
either.
beyond the Tupperware.
And, you know, I've had students say, well, you should have reported that, and I said, what?
Ooh, okay.
Theft of a corpse?
Yeah.
That's not child abuse or elder abuse. Okay, those are crimes for which there are no reporting statutes. Okay, and I learned about it in the context of the mediation. You know, I had attorney-client privilege as a lawyer. Okay, but apparently we have some Satanists among us.
If you're in this.
Just now figuring that out.
Did they settle?
What?
How did the case end?
No, we settled the other stuff. Basically, if I remember right, there was like $10,000 equity in the house, $10,000 in retirement dollars. She didn't need the money, okay? And then, quite frankly, the dad realized then why the divorce hadn't been accounted, because she didn't need anything,
Yeah.
okay? And he ended up agreeing to pay her, you know, maybe 10 grand in some way. I don't remember the number, and they split up the other stuff. So. All right, well, thank you for your time and attention.